I would like to introduce to you our speaker today, Monica Bryant. She's with Triage Cancer. Really excited about her presentation today. Thank you, Monica, for being with us.
Thank you so much for having me. So welcome, everyone. We are going to spend a little bit of time talking about getting your ducks in a row, which is really coming down to planning ahead, which includes estate planning. But before I get into the heart of today, I want to just tell you a little bit about Triage Cancer, which is the organization that I co-founded and am chief operating officer for. We are a national nonprofit that provides free education on the practical and legal issues that arise after a cancer diagnosis. And so certainly that includes estate planning, health insurance, employment rights, disability insurance, finances. So what we really try to do is address those practical and legal issues that can really add to the stress and anxiety of a cancer diagnosis and treatment. We provide the education in a couple of different ways. We participate and host events all over the country. One of the events I wanted to just bring up today is our Triage Cancer Conference. It's totally free to attend, open to anyone who wants to learn more about these issues. We're hosting it online, May 21st, and registration is still open. I bring that up really because I want you to know that today is not your only or your last opportunity to get information about these topics. And then throughout today's presentation, I'm going to point you to some of our other resources that are specific to estate planning. Now, even if you attend our events and look through our resources, you may find that you have really specific questions. You may even find that you have questions you don't feel comfortable asking today in sort of a public forum. You are more than welcome to reach out to us through our legal and financial navigation program. This is where you can fill out a confidential form on our website, and you'll get an email with a link to schedule an appointment, and you'll talk with one of our expert staff about your situation. So we don't provide legal representation or fill out forms, but we really do try to explain your various options, the pros and cons of those different options, and then provide you with the next steps to take. So again, wanted to lay all of that out up front because we're going to talk about a lot of different things today, and it can be a relatively emotional topic. And so I know sometimes it's hard to get those concrete questions out in the sort of heat of this. All right, getting into it. What is estate planning? What do I mean by estate planning? Generally speaking, we're talking about the process of creating a plan to make sure that your wishes with respect to what happens to your property, to what happens with your healthcare, and who's going to care for your loved ones are carried out in your absence. Now, talking about estate planning is one of my most favorite topics to talk about because I think it can be incredibly empowering, but I also recognize it's a really hard thing to talk about. At the end of the day, we are talking about our own mortality, and that is scary. That is a hard thing to talk about. So recognize that I'm going to give you some very practical things to do today, but I'm not doing it sort of ignoring that it is challenging to talk about. But here's the thing. There's one thing that is actually true for each and every single person. At some point, we are going to die. And so kind of recognizing that and sitting on that, certainly we hope it's a long, long time away, but it helps to take some of that emotion out of estate planning sometimes. So who needs an estate plan? Well, I would argue certainly Beyonce and Jay-Z, who probably have as much money as most small countries, probably need an estate plan. This lovely lady, who is currently the oldest living human in the United States, could certainly benefit from an estate plan. Without a doubt, this young family with small children need an estate plan. These young professionals who are maybe just starting out in their career need an estate plan, even if they feel like the only thing they have in their pockets is a whole bunch of debt. And then I would even argue these two young ladies who may not even be 18 yet could actually benefit from writing down their wishes. Now, here's the thing. I am assuming that you are coming today because maybe you haven't planned your estate yet, or maybe you feel like you haven't done all the pieces that you need to do. If you are in that boat, please recognize that you are not alone. Unfortunately, a great number of Americans have not planned their estate, including these very famous examples, all of whom had quite a bit of money and a large estate. And so if you're feeling guilty that maybe you haven't planned your estate yet, please know, again, you are not alone. 68% of Americans don't even have the most basic estate planning document. So I applaud you for being here today. Why do we plan our estates? Well, I think there are lots of different reasons, and some of these may or may not resonate with you. Hopefully you find one reason that does resonate with you. I think documenting your wishes is an incredibly empowering thing to do. Certainly there are financial reasons you may need to plan an estate. There are tax benefits sometimes for planning an estate. I think peace of mind. So particularly if you have small children or a complicated family, knowing that it's all planned and done can provide some peace of mind. If you're like me, it's sort of that check on the to-do list, it's done. It's also an incredibly loving thing to do, because here's the reality of the matter. By planning your estates, you are taking the burden of trying to figure out what you want, what needs to happen with your property, who's going to make decisions for you. You're taking that burden off the shoulders of your loved ones because you're doing it. And your loved ones then, in their time of stress and grief and sorrow, aren't trying to figure these pieces out because you've already done it. So estate planning is a really loving thing to do. And then finally, yes.
We have a question that came in.
Yes.
Do you have any suggestions for helping family talk about estate planning? She says she's the one with stage 4 and she's willing to talk about it, but they don't.
So that's a tough one. There are definitely some strategies. I think I would make a nod to perhaps our friends in the social work community. So if you have access to a social worker that you're already working with, or perhaps a therapist or a counselor, sort of those healthcare professionals can be really helpful to facilitate those conversations. If you are religious and have a religious leader, sometimes those people can help facilitate the conversations, because by bringing in that third party, it can sometimes take that. It's also hard to talk about in this vacuum because I don't know why your family is hesitant. So sometimes we hear from people that the family has this attitude of don't give up, keep fighting. I don't want to talk about this because we're not giving up on you kind of mentality. So in that case, perhaps bringing in a third person to sort of talk about all of the different feelings and give you space to have a voice. But maybe also it's about talking about these pieces, right? That it's not necessarily that you want to plan your estate because you're stage 4, it's that you want to plan your estate because that's what we all should be doing. And in fact, if your family members haven't planned their estate, they should be doing it too. And let's all do it together and let's go through this process together. So I am a lawyer, I am not a healthcare professional. And so that's sort of my practical answer, but I would definitely suggest if you have access to a social worker, maybe they might be able to give you some more sort of practical tips. So let's say you are starting from scratch. Where do you start with your estate planning? I think these are the 4 most common questions. What do you want to have happen to what you own when you die? Are there people that you are legally responsible for, like minor children? Are there people that maybe you aren't legally responsible for, but you do want to take care of? And if you are unable to make decisions, who do you want to make those decisions for you? Once you've thought through those very big picture questions, we have to start drilling down a little bit. So to answer the first question, you have to know what it is you own. So to figure out what your property is, you can do a physical inventory. So certainly if you have a home or land Personal properties, anything you can kind of hold, like a record collection or a wedding ring, those are going to be personal property. But then you have to think about the non-physical things you might own. So bank accounts, retirement accounts, life insurance policies, stocks, bonds, those are going to be non-physical pieces of property. Then once you know what you own, sometimes it's helpful to know what it's worth. A lot of times I will hear, particularly from parents, if they have multiple children, they want to split their estate evenly between the different children. Well, in order to figure out how to do that, you have to know what the things are worth. How do you figure out what it's worth? Well, for real property, certainly an appraisal could do it. Get a person to come in and appraise your home, take your ring to the jeweler to get the appraisal. But I would also caution you or encourage you to think not just about the monetary value of things, but the sentimental value of things. For example, in my family, we have a cedar chest that was passed down by my great-grandmother, and it is one of the few things that she passed down. If I were to go and sell that cedar chest, I'd probably get a couple $100 for it. But the sentimental value of that cedar chest is enormous to me. And so I have encouraged my mother to include that in her estate plan. If I am lucky enough to receive that cedar chest, it will go in my estate plan. So think about those things that you want to make sure keep getting passed down. Now we know what we own and what it's worth. We have to figure out how we own it. So there are different ways to own property. If you are the only person that owns it, like you have a car, only your name is on that title and it's paid off, that's what's called sole ownership. But many times we own things jointly, and there's different ways to own things jointly. So the first is called a tenancy in common. So imagine that you have an apartment building with 4 units. You own 2 units, your best friend owns 2 units. In a tenancy in common, your best friend could put her 2 units in her estate plan, and you would put your 2 units in your estate plan, and it would get passed down that way. That is different than something called joint ownership with right of survivorship. And this is how a lot of married couples own homes. In this case, both couples have full ownership. So when one of the spouses passes away, full ownership immediately transfers to the other spouse. This is important because depending on how you own something jointly will dictate how you deal with it in your estate plan. All right, so now we know what we own, how we own it, what it's worth. What actual documents do we need? These are some of the most common documents, and I would argue that everyone over the age of 18 needs 3 of these. So let's go through them in turn. A will is a legal document where you deal with most of your property and assets, and it's where you deal with guardianship of minor children. Why do I say most of your property? Well, there's some things that you wouldn't put in a will, like a life insurance policy or a retirement policy. And that's because those policies, the moment you acquire them, you write down who the beneficiary is going to be. So when you buy a life insurance policy, you say, if I pass away, this money goes to my husband. So you wouldn't also put that in your will because it's already been dealt with. There are different types of wills. Holographic wills are handwritten wills. There are statutory wills, which are like fill in the blank wills. There are wills prepared by a lawyer. One of the most common reasons I get from people as to why they haven't planned their estate is they don't want to pay for a lawyer or they can't pay for a lawyer. Please don't let that be the reason that you don't create a will. There are sometimes free services by local bar associations. There's a website called freewill.com where the site asks you questions and you type in the answers, and then at the end it populates a will that you can print out and execute. There are also some services like LegalZoom or Rocket Lawyer where they do charge a fee, but it's a pretty nominal fee for a basic will. I would say under $50. So there are lots of ways to get a will done that don't involve a lawyer. Are estate planning attorneys useful? Maybe. If you have a super complicated estate or a super complicated family, then maybe having a will drafted by a lawyer makes sense for you. But for many of us, maybe you have a home and you're trying to name guardians for your children, using these online services or a statutory will is totally sufficient. So I said that freewill.com is a service where, it pre-populates and then you print it out. Well, then what? How do you actually create a legal will? It does depend on the state. I'm not quite sure where all of you are from, but in most states, the testator, that's you, the person creating the will, has to be over 18 and of sound mind, which is the sort of legal standard for saying you understand what it is that you are doing. Sometimes we will get calls from family members of patients who are maybe dealing with Alzheimer's, or because of treatment, they're really just not mentally where they were. And they ask us, like, is it too late to do a will? And the answer is maybe. Would it be contested? Would a court say that they're not of sound mind? Don't let it get there. Do these wills before you get there. Generally, wills have to be in writing, signed and dated by you, and then witnessed by two uninterested people. That means, generally, if somebody is named in your will, do not have them be your witness. The witnesses have to be people that don't benefit from your estate in any way. And this is another place where people sort of get hung up. They're like, what do you mean? Like, I can't have a family member because they're all in my will. I had a next door neighbor witness my estate planning documents because she is not in any of the estate plans. So think outside the box when you're looking for witnesses. When you are thinking about, yes.
Sorry, before you move on, I had another question come in. I'm in Texas and I've heard they don't accept things like LegalZoom. Any suggestions for states?
Yeah, so freewill.com. And I would also say, I believe Texas has a statutory will. And at the end of the presentation, I'm going to talk to you about our estate planning toolkit and what's included in that. So hang tight. So when you are creating a will, there are some pretty specific decisions that need to be made. So the first is, who are the beneficiaries? So who is going to benefit from your estate? The beneficiaries can be general, like, I'm leaving everything to my only child, or they can be really specific. My son gets my record collection, my daughter gets my antique cars, or some combination thereof. And beneficiaries don't just have to be people. They can be institutions like a hospital or a university. They can be a charitable organization like a nonprofit that's been helpful to you. And again, they can be some combination thereof. So who's going to benefit? Then if you have minor children, who's going to be the guardian? Generally, when you're picking a guardian, not generally, when you're picking a guardian, you want a primary guardian, one person, and then alternate guardians after that. You don't actually name co-guardians like a couple. And then finally, the last sort of big picture thing is, who's going to be the executor? The executor is the person who has to sort of deal with the business behind closing out your estate. Certainly, it could be a friend or a family member. Some banks will offer this service for a fee. Estate planning attorneys will do this for a fee. So there's options with the executor. When you're thinking about picking a guardian, there's actually two different pieces. So there's the guardian of the person, and that's the day-to-day, getting the kids to school, bathing, lives in the house with them. And then there's the guardian of the estate, which is about potentially their financial well-being. So if there's a trust in the child's name. Now, a lot of times it's the same person that parents will pick, but sometimes maybe it needs to be two different people for a number of reasons. And then thinking through sort of the things that matter most to you in the human being that you choose to take over raising your child. And so some of the things that have come up over the years have been making sure that the child is raised by someone with the same characteristics. And I really hate that word, but I haven't come up with a better one. So that could mean race, religion, politics, sexual orientation, or gender identity. If those things are important to you, think about guardians that manifest those things. Because again, you know, if you have strong values and beliefs that you want passed down, you need to articulate those. When we talk about an executor, these are just some of the possible duties. So filing the will and probate, figuring out where all your assets are. They're the person that kind of notifies all the companies and the agencies. They may have to file taxes on your behalf. So it can be extensive. So again, picking someone that is willing to take on this role is very important. Now, in addition to I can't hire a lawyer being a reason for people not creating wills, the second most common reason is, what if I want to change it? You can change your will as often as you'd like. The piece to remember, though, is when you go to change your will, you have to do it through something called a codicil, which is basically an amendment to the will. So it can't be scratching things out and writing in the column of the existing will. The courts will actually ignore all of that when deciding, you know, who gets what in your will. So you have to do what's called a codicil, which is an amendment, and it has to be executed the same way your will is. So if your state says signed and dated by you and 2 uninterested witnesses, that's how the codicil has to be done as well. So please don't let a fear of like, what if I want to change it later, be the thing that stops you. What happens if you don't have a will? Well, you will have a more complicated probate process. It's going to be more expensive, which means money being taken out of the estate to pay for probate and less money going to the people that you might want it to go to. It's going to take longer, but most importantly, it takes away your choice. So property, when there's no will, property gets distributed by statute. Every state has what's called an intestate statute, which basically is a distribution to your family members in a particular order. But again, you lose all control over that. So my message to you is create a will. The second legal tool or estate planning tool that I want to talk about are trusts. Trusts are actually where it's a legal entity by itself, and it's where you transfer ownership of property to the trust. Then the trust has somebody called the trustee, which is the person who is in charge of making sure that the trust is managed for the benefit of the beneficiary. So the beneficiary is the person that the trust is for, and the trustee is the person that manages it to make sure that everything is going right. So what goes into a trust? Land, bank accounts, artwork, intellectual property rights. The trust can actually be the beneficiary of a life insurance policy, for example. So why do people set up trusts? There's control, there's financial reasons, particularly if there are minor children involved. It's a way to protect those assets for minor children. But trusts are never a substitute for a will. There are things that a will does that a trust can never do, like name a guardian for a minor child. There are also things that you might include in a will that don't go in a trust, like my cedar chest, right? I wouldn't pay to create a trust for my $200 cedar chest. It's just not worth it to do that. So those are the things that could go in a will, even if I had a trust. There are different types of trusts. The most common is what's called a living trust. And the way this works is someone creates a trust, transfers ownership of all of their property into that trust, and then they are trustee as long as they are alive, which means that they can sell the property that's in the trust, they can add new things into it, they can change the stipulations around a trust as long as they're alive. When they pass away, whatever they have decided is going to happen to that trust and the property in that trust takes over. And so I know there was a question about, well, I'm considering a trust, but can I make changes to it? Yes. And the way to do that is to create this type of trust, which is a living trust. So why do people do these trusts? I think there are many reasons. Again, I know particularly for parents with minor children or even older children, they create trusts to provide some protection. So even college age kids, most college age kids wouldn't responsibly handle any sort of influx of money. And so trusts can hold on to that money or that property until certain stipulations are made, until the child graduates from college or has their first job or turns 26, or sometimes we hear it about my cousin has a gambling problem, and so their cousin is only going to get like rent paid out of the trust for the rest of his life because he can't handle the money. So there's a question about college age children, seniors that are graduating from high school. Are you still able to appoint a guardian if they are under the age of 18? Yes. So in this country, we're not legal adults until we're 18 and can't make a lot of legal decisions. And so depending on the age of that senior going into college, you can still name a guardian. Also, I will say for individuals, adults who may have cognitive disabilities, who maybe can't manage their own finances, you could also appoint a guardian in those cases as well. Now, I talked a lot about how wills can be done DIY. You can, in theory, create a sort of DIY trust. However, depending on how complicated you make the trust, it might be worth it to talk to an attorney. And the reason trusts are different than wills is with trusts, you are literally giving up ownership and transferring that ownership to the trust itself. And so you want to make sure that it's done correctly. All right, so sometimes there are situations when you are still alive, but for whatever reason, you are unable to make your own decisions or communicate your wishes. In that case, there are two documents that can be incredibly useful. The first is a power of attorney for financial affairs. And this is where you name an individual, an agent, to make financial decisions on your behalf. There are two main types of powers of attorney for financial affairs. There's standing, which means the second you sign that power of attorney, it goes into effect and that person can make those decisions on your behalf. And then there's springing, which means you sign it today, but it doesn't go into effect until you become incapacitated. Maybe you get into a car accident and you're unconscious on the scene. That was when it would start. Powers of attorney for financial affairs have to be signed, and many states require that they're notarized. But the power of your agent ends the moment you pass away. So again, it can't be used as a substitute or instead of a will. It's something you have in addition to a will, different purpose here. So what kinds of things can a power of attorney for financial affairs do? They can pay your everyday bills, healthcare bills, they can handle your taxes on your behalf or sign applications for government benefits like Social Security disability insurance or Medicaid, for example. And so you'll see there sometimes, particularly in the cancer context, having that standing power of attorney can be really helpful because you might just be overwhelmed and not able to deal with these day-to-day things. By naming that power of attorney for financial affairs, they can act on your behalf, even if you are not incapacitated. So there's some benefits there. So that's how you handle the financial piece. How do you handle the medical decisions? So collectively, there are some documents called advanced healthcare directives, but there are some pretty important distinctions between the different directives. So the first is called a living will, also known as your instructions for healthcare. And this is where you get to write down your wishes for the type of healthcare you will or won't receive. And that can include things like antibiotics, artificial hydration, pain management, blood transfusions. In your instructions for healthcare, you can also document the location of treatment. So I recently spoke with a woman who was adamant that at end of life for her, she wanted to be transferred to hospice because she didn't want her children's last memories of her in their home to be of her passing away. And that was so important to her. We created a living will, and she created a living will and was able to document that. So there was no questions when that time came. Living will is also where you can talk about your wishes around organ donation, burial wishes, cremation, etc. But here's the thing. We typically cannot think through every possible permutation and medical situation that could arise. So then what? In that case, you can actually appoint a power of attorney for healthcare, which is where you name an agent to make medical decisions for you if you are unable to. Now, one of the challenges with this is depending on where you are and who you talk to, there is like 100 names for this. Agent, proxy, surrogate, representative, attorney, in fact, it's all the same thing. It's a human being that you have named to make those medical decisions on your behalf. With all of these people, it is helpful to name a primary agent and a primary guardian, and then alternate agents in the event that your primary agent is unavailable or can't make the decision. They would go down the list. But it is never a good idea to name co-agents, because what happens if they disagree? Then all your planning and pre-thinking is for naught. So name one and then name others in order. Who can be an agent? Almost anybody, except they do typically have to be over the age of 18. They can't be your healthcare provider or be sort of providing you with other life care. What are some things that a healthcare power of attorney can do? Well, they can decide what tests or procedures or medications you might get. They can decide on moving you to a nursing home. They can also make some decisions around hiring or firing certain healthcare providers. And provided that you haven't indicated your preferences in your living will, they can make decisions around organ donation and final disposition. There are some limitations by law of an agent, but there's also an opportunity when you name an agent to limit their powers, so to speak. So again, if there's very specific things that you want, that you don't want your agent to override, you can list that in your power of attorney for healthcare. So you can have just a living will where you've written down all your preferences. You can just name an agent. But the most protective thing to do is actually to have both. And when you have both, that's what we collectively refer to as an advanced healthcare directive. Why have both? Well, a couple of reasons. One, we can't always think about all the things that might happen. And so naming an agent kind of fills in any potential gaps. Two, by writing down your instructions for healthcare in your living will, you are helping your agent sort of breadcrumbs of what you may or may not want in certain situations. And so having both is incredibly helpful. Some advanced healthcare directives also have some other parts around resuscitation and organ donation. With advanced healthcare directives to be valid, you do in fact have to have them signed and witnessed. Now, you could name the same person as your power of attorney for financial affairs and your power of attorney for healthcare, but it doesn't have to be the same person. So if you think, my best friend is the most empathetic, loving, amazing person in the whole world, of course I would want her making my medical decisions for me, but she is terrible with money, maybe you name her as your healthcare agent and your accountant brother-in-law as your power of attorney for financial affairs, right? So it doesn't have to always be the same person. It also doesn't have to be a spouse. I have a lot of people that default to spouse or partner, which there's nothing inherently wrong with. But if you stop and think about when this person is making these decisions, the person that they love, presumably more than anybody else on the earth, is in a bad place. And so in the fog of that grief, they're now going to have to make these decisions. That can be a lot. So maybe your spouse or partner may not be the best person to make those decisions. So I kind of just bring that up because I think sometimes we get stuck in a box of what we should or shouldn't do when naming agents, but there really shouldn't be a box. Okay, so what happens if you don't plan ahead? Well, courts get to appoint what's called a conservator. We've all become more familiar with conservatorships because of Britney Spears, I feel like, but there are two types of conservatorships. There's a conservator of the person and the conservator of the estate. The challenge with conservatorships is multiple, but there are some places where there are just volunteers who have agreed to be conservators. And then your case comes up and judge points to stranger and says, stranger, you're now this person's conservator. So you could have a perfect stranger making decisions for you if you don't plan ahead. Now, there are a whole bunch of other things that I hear tossed around in the cancer community as wills that are not actually legal wills. So ethical wills or legacy letters are lovely and they have multiple purposes and I think can really be very helpful, but they're not actually a will. And so typically these are where people will write down their hopes for their children or future generations. They will outline their beliefs and their greatest joys. And these are really incredibly lovely, particularly for parents of smaller children. So I'm not saying they don't have value, they absolutely do, but please don't mistake it as the same thing as a legal will. All right, so what are some other things to think about? Who needs access to things? So are you the only person with the key to your home, or are you the only person that knows where your safety deposit box is, secret storage units, or the only signatory on your bank account? All of those things create barriers if something were to happen to you. Now, certainly you do want to kind of keep things locked down, but make sure, at least one other person knows that these things exist. The other thing that we have been talking more and more about lately are our email and cloud accounts and social media. I did this presentation a couple of weeks ago and some woman was like, are you kidding? I'd be so happy to be like free from my inbox. And while I feel that, we have so much now attached to our email addresses. So access to online bank accounts, bills that come in electronically. Usually our email is attached to a cloud account. And I don't know if you're like me, but every picture of my children since the day they were born is sitting on my iPhone. So if they were to get rid of my cloud account, their entire childhood would poof, be gone. So thinking through those non-physical properties can be really helpful. And then who has access and what's there. Also with social media, it's the same thing. For a lot of people, social media sort of chronicles their lives for the last however many years. There are different things that can be done with social media accounts. Different platforms have different mechanisms. So Facebook has an opportunity to name a legacy contact, and they're the person that could go to Facebook and present, a death certificate and say her wishes were to turn this into a memorial page where it was very clear loved ones could come and post messages and revisit pictures and memories. Gmail, for example, has an opportunity to name an account manager where if you passed away, they would have legal access to deal with your, what they call digital afterlife. So how do you organize all this? Because I know it's a lot. This is one strategy. This is Triage Cancer's financial big picture document. And in this document, you can actually list all of your assets. So homes, cars, accounts. You can also list liabilities. So this is helpful because if your executor has to figure out, okay, well, who does your estate owe? This can be really useful. And then there's a place where you can actually put in all the login information and any notes that you might have about those particular accounts. Of course, you want to keep this in a very safe, locked down place. but maybe at least let your executor know that this document exists so that they're not trying to, hunt through drawers and drawers of filing cabinets, for example. So once you've created all these documents, what do you do with them? Well, I think that it's helpful to gather not just the account information, but actual documents that you might have. So certainly a will, an advanced healthcare directive. If you have a life insurance policy, that documentation, any passwords or keys to cars, all those things should be kept in a secure location. And at a minimum, the executor to your estate should know where that is. But what about sort of outside of your executor? For documents like your will and your advanced healthcare directive and your power of attorney for financial affairs, those are not things that should be kept in the lockbox that only one person knows about. Because if you think about the purpose of these documents, it's to be helpful in an emergency. And so if that person doesn't get reached, how is anyone going to know you've taken the time to create and write down your wishes in these documents? You want to make sure people have access to them. And I could tell you hours and hours of stories of situations where they couldn't find the documents. So what do? You could literally photocopy them and give them to your hospital to put in your electronic medical record. You could give it to family members, your clergy, if you're close to a clergy member. My strategy, if it is helpful for anybody else, is to use technology. So I scanned all of my documents. I created a Google Drive folder. It's free if you have Gmail, and it's my estate planning documents. And the guardians I've named for my children, my executor, and my 2 powers of attorneys all have links to that Google Drive. They save the links in their email. So wherever they are in the country, if something were to happen to me, they could access those documents. And what's helpful about this one folder is that if I make changes, I just take out the old documents and put in the new documents. And there's never going to be any discussion about, well, which ones are still valid. There are paid services that you can use like Master Lock Vaults, but I really think it doesn't have to be that complicated. Google Drive, iCloud, Dropbox, those are all things that can be utilized and really helpful. Another practical strategy is utilizing your smartphone if you have one. So smartphones have the ability to put in emergency information. So you can put in any medications you're taking, you can put in a emergency contact, and then there's a notes section, at least in iPhones, where you can name has an advanced healthcare directive, call this person. And so that way first responders are trained to access this information in an emergency, and they can get to it without unlocking your phone. If that's sort of too high tech, or I know some people have issues about the cloud, which I get, there's jewelry you can wear. And I just recently came across this Apple Watch band, which I thought was very unobtrusive and might be a good option for some. And then kind of in our last couple of minutes, till I open it up for questions, some other things that are sometimes helpful to think about is funeral planning. Funerals are really, really expensive, and it can be a big burden on your loved ones if you haven't planned anything or documented anything. So what are some possibilities? There's funeral insurance you can buy. There's prepaid plans out there. There are opportunities to document your wishes. So if you want to be buried, you can actually go to a funeral home now and sort of pre-purchase everything. It's hard. I think it can be hard. It can be emotional. But I want to share just one story of why I think it's really helpful. A gentleman called us. His wife had just passed away, and he was in a bad financial situation. And we were sort of talking through all the things. And then he mentioned that he probably spent more money than he should have on his wife's funeral, and that money should have gone to bills. So we kind of talked a little bit more, and he shared with me that when it came down to it, he bought her the most expensive coffin because he couldn't bear with the guilt of putting her in the bargain coffin. And so then I stopped and I said, okay, that's understandable. What do you think your wife would have chosen if she had made that decision? And he laughed and said, there's no way she would have even asked if there was a coupon version to buy the cheapest one. And so it was just an interesting example of, it's, again, that very loving thing to do it ahead of time, because there's a whole lot of emotions balled up in these decisions. There are also some services around sort of pre-planning gifts or messages. And then to the question earlier, you know, it is incredibly important to have conversations with your loved ones about your decisions. And I know it's an easier said than done situation, but I think it is not only important for us, the people who are planning our estates, but it's important for our loved ones to know what our wishes are. You're going to go through all of this work, make sure that your wishes are in fact honored. So when you create an estate plan, it has to be one that works for you. You may feel like you need a will, a trust, and a power of attorney, and a, you know, advanced healthcare directive. Some of you might not need a trust, and so you really have to kind of figure out the pieces for you. Review your plan periodically. You will have changes in your family. You might have changes in your asset. You buy or sell things. You might have changes in your wishes. So feelings change over time. And so making sure that you are sort of periodically, once every however long makes sense to you, 6 months, year, just reviewing it. Yep, those are still all the people I want to be making the decision. And yep, that's still what I want to have happen to the property. I know I harp on this so much, but please make sure that someone knows where all the pieces are. Entire semester in law school on estate planning, and half the cases were about missing documents because no one told somebody where their documents were. And then discuss the plan with everyone involved. So anyone you've named to be an agent, anyone you've named to be a guardian or an executor, make sure all those people know the role that they're playing. And sometimes it can be helpful for them to know who's playing the other roles in the event that they need to communicate. So as promised, Triage Cancer has a state-specific estate planning toolkit. It's in 3 different parts. The first part is a lot of the basics. So it's a little bit more about what I talked about today, the different documents and how to execute them. Part 2 is about any state-specific rules for your state. And we have it for all 50 states. I've given Texas's link here as an example. And then part 3 are the actual forms. If your state has sample or standardized forms to fill out, we've compiled all of those into one document. And so this can be accessed and printed from our website if you just go to Estate Planning Toolkit. And so I definitely recommend, to the question earlier about suggestions for weird states, to look at what's available in your states. And then before I open it up to questions, I just want to remind you that if you have questions after today on estate planning, health insurance, employment, finances, know that Triage Cancer's legal and financial navigation program can be another resource for you. All you have to do is go to our website at triagecancer.org/gethelp and fill out an intake form. Tell us a little bit about your question. Be on the lookout for a scheduling email, and then wait for the call. And we will have a call with you to talk through your different options. So that's all I have. So Elaine, if there are other questions that popped up.
Yes, we do. We have some additional questions. So are there any unique things to consider for younger people that may not have as many assets?
In those situations, I might ask about, well, what assets do you have? If it is things like a home, then maybe a trust might make sense. But if it's more like personal assets, a bank account, a car, then maybe a will, just a will, is sufficient. But I would say, you know, that's still important. The will is still important to deal with those particular assets. And then really consider the power of attorney for financial affairs and the power of, or the advanced healthcare directives, because those aren't about assets at all. Those are about your wishes.
Great. We do have another question. Would you please share tips on how to sell an existing life insurance policy to cash out and have funds to live on instead of letting it expire, or needing the funds to live on instead of leaving to others?
Sure. So there are definitely companies out there where you can either sell your life insurance policy. There's also some companies out there where you can use your life insurance policy as collateral for a loan. And so that might be a good option for you. What I would recommend is to read through, if you go to cancerfinances.org, we have a whole module on life insurance, and we have a whole module that talks about how to potentially sell or use your life insurance policy as collateral. So I'd recommend reading through that first to look at your different options. And then if you still have questions, reach out.
Okay. What should I do about my retirement savings? I have no spouse or children to bequeath it to. And so what are the financial implications, such as penalties, taxes, if she cashes out her retirement savings or her 401k and state pension?
So those are going to be specific to the different policies. So you really need to go back and look at those policies, and the best professional to talk to about that is a financial planner or an accountant, because there are going to be various tax implications to that based on your tax bracket and where you live. The other challenge is if you are receiving any sort of benefits that are asset-based, that could potentially cause a problem. There is a nonprofit called Savvy Ladies. You can find them on our website if Google doesn't work. But they actually provide connection for women to pro bono financial planners. And so you can reach out to them, let them know Triage Cancer sent you, and see if you can connect with a financial planner. And they'll be able to look at your specific pieces and your tax bracket and the different retirement accounts you might have to figure out what makes the most sense financially.
What was that website again?
Savvy Ladies.
Awesome. Great. Thank you.
I'm sorry, I can't remember if it's .org or .com, but they are a nonprofit, so it might be .org.
Wonderful. Thank you for that. So who has the responsibility for our medical debt? So how long is the debt alive? If your estate is closed, can someone make claims a year later?
It depends. So it depends on sorry, I guess I should clarify. If you're talking about once someone passes away, what happens to medical debt? Then the answer is, well, did anyone sign as a guarantor? So did a spouse sign as a guarantor? Then yes, the spouse might still be responsible for that even after you pass away. If it is while you are still alive, there isn't actually a hard and fast time frame as to when medical debt goes away.
And one final question. If you are married and your husband does not want to make a will now, your own several properties and different investments, and you are concerned, can you do a will without him?
Yes. So here's the thing. Wills are for an individual. So it's not like a married couple goes in and creates one will. Spouse one gets a will, spouse two gets a will. You hope that there's some conversations in there so that there isn't conflicting information, particularly if you own that property jointly with right of survivorship. But I do think if there's anything that you own solely, like those investments or retirement account or any of your personal property, you may absolutely do that will without him being involved. With respect to your properties, I'd have some more questions about how you actually own them, but please don't let a spouse or partner's hesitation stop you from at least creating a will, and certainly don't let it stop you from creating those advanced healthcare directives and powers of attorney.
Wonderful. Sorry, I know I said that was the last question, but I'm going to ask you one more. What is the difference between whole and term life insurance?
So just in case anyone has to jump off, I want to just say we have a whole life insurance module on cancerfinances.org that talks through all these different pieces. But super briefly, the major differences are term life insurance is for a term. So you pay X amount of money per month for a Y amount policy. So if the term is a 10-year term, you pay, and I'm making up these numbers, you pay $50 a month for 10 years. And if you pass away in any of those 10 years, you get the $200,000 that the policy was worth. At the end of 10 years, there's a reassessment of what your current health status is, and it starts a new term. And so once the first 10 years expires, the premiums can jump, particularly if you've had a serious medical diagnosis. It jumps no matter what, because age is a piece of that puzzle. Whole life insurance is more complicated because there's different types of whole life insurance, but it's more like a savings plan where you're paying money in. There's no specific time frame to it, but the premiums change as you typically get older. So there's some pretty important distinctions there. What I would say is if you currently have a life insurance policy and you've been diagnosed with cancer, it's helpful to hold on to that because it becomes much, much harder once someone has any pre-existing condition to access life insurance.
Thank you, Monica, for joining us today.
Thank you. Have a lovely day.
Have a great day, everyone.